Let's analyze it having an example of 6 questions on the exam and you have to answer 3. What do we do then? You could study like 4 topics, just in case you don't get the question you were expecting and you have one backup topic. Disposition covenants and enforcement, leases and licenses, business lease renewals, forfeiture, repairing obligations. Those are topics that most often come up on commercial property law exams. It is very important that you have a look at your past exam papers of your particular university and then analyze what kind of questions you're most likely going to get. So what kind of problem questions are you going to get on these topics? What kind of essay questions are you going to get on this topic? So if you have a look at past exam papers of at least 2 or 3 years, as much as the university provides, you will be able to prepare for your exam very well, because usually exams are very similar to the ones the year before. How do you answer a problem question? This is the overall structure. Firstly, you need to identify the issues, the legal issues raised in the problem question. Secondly, you need to research the law and find the relevant rule. The third part is the most important and the hardest, application and analysis. So here you have to apply the law to the facts of the case that you're given and provide analysis, provide arguments. What would be the most likely outcome if this case went to the court? What do you think? What would be the judgment? And then you have to sum up your analysis and conclude. Disposition covenants is also a very important topic. What does it mean? The disposition covenant is when tenant may want to assign or sublet their premises, and these are the covenants in the lease that regulates subletting. They have an option to do this, but most of the times it's limited. The tenant has to ask for permission and they can be rejected. So it's not guaranteed that they will get this option to sublease, subassign. And the most important in this case is to get the permission according to the law. And if you get a problem question on this scenario, most of the analysis is required on this reasonableness requirement. So did the tenant ask for the permission within the right time according to the law? And then if the landlord rejected, and most of the problem questions landlord rejects on this topic, so then you have to analyze whether or not the rejection was reasonable. So these are the problems that you have to be very well prepared to answer for your exam. So main problem that can occur, as we already said, is if there is a breach of covenant and the tenant assigns the property to the assignee. And in this situation, the landlord can forfeit the lease because the tenant breached the actual or qualified covenant, and everything will be destroyed with regards to the lease. These are the relevant sections from Landlord and Tenant Act that you will need to use in a problem question on this topic. Section 114, when landlord cannot charge the tenant and make it financially unviable to assign the lease. Section 19, very important, that's a reasonableness requirement. Landlord has to be reasonable when there is a qualified covenant, and whether or not refusal was reasonable is Section 19 that guides that analysis. Now, the problem question, you will have to most likely have to assess whether or not landlord was reasonable. So make sure that you understand Section 9 very well and make sure that you are prepared to provide a very good analysis on this topic by knowing the right case law, the right key principles, and so on. We have model answers on this topic. So it's highly recommended that you go to our website, simplestudy.com, go to commercial property law and have a look at our resources there. Our notes summarizes very well what are the key principles and the key cases, and our model answers gives you an idea of what you're expected to do on your exam. Example problem question is the following. In January 2018, the cafe manager at Breakfast Club departed and Tehran requested Sicilianos in writing for consent to assign the lease of number 3 to Jeremy. Jeremy owns a local chain of coffee stalls and breakfast, lunch and dinner shops. A month later, Siciliano's agent called Tehran to tell him that he did not want to give consent to assign the lease, the reason being that the potential assignee may breach covenants of the lease and other grounds as well. Now we have to assess whether or not the refusal was reasonable. You can see the full answer at this link. And the best practice would be if you just read the question without reading the answer, and then you can try to answer the question yourself, and then compare your answer to our answer. Here we only analyze some part of the answer, so it's you will have to go to the link before in order to read the whole answer. Although clause 10 states that the tenant cannot assign without the landlord's consent, as per section 19, Landlord and Tenant Act, every qualified covenant against disposition is deemed to have a reasonableness provision which does not allow unreasonable refusal. Then we have to go in more detail of what this unreasonable refusal means. As per section 1 of the Landlord and Tenant Act 1988, consent must be done within a reasonable time unless there is a good reason to withhold it. This must be in writing, and the breach of this duty may entitle a tenant to damages as per section 4. As per the Law of Property Act 1925, the landlord may not exact a fine for license to assign or sublet, although reasonable legal fees may be sought. Where refusal was unreasonable, the tenant may go along with assignment as per Tree Law versus Big. However, the tenant risks the landlord undertaking for future proceedings. So as you can see, we have to mention all the relevant sections of the statute as well as the case and advise the party. However, this is not the coursework level of answer. This is only a practice as a level of analysis you would be expected if you have an exam where you're only given up to an hour for drafting an answer. So take that into consideration. The notice is given on the model answer if you go to our website. So then after mentioning the case law and after mentioning the relevant statute, you will have to apply this law to the facts of the case. The first issue to be dealt here is whether or not consent was reasonable. Bates versus Donaldson, disposition covenants are used to protect the lessor from having premises used or occupied in an undesirable way or by an undesirable tenant or assignee. It's not to coerce a tenant to surrender the lease to obtain possession. Refusal must also be one relating to the personality of the proposed assignee or to the subject matter of the lease, as per Holder Boss versus Gibbs. The leading case is International Drilling, which confirms Bates and Donaldson principle and expands. It states that the landlord is not entitled to refuse consent to an assignment on grounds which have nothing to do with the relationship of landlord and tenant in regard to the subject matter of the lease, not necessary to show conclusion justified, once they might be reached by a reasonable man in the circumstances. It may be reasonable to refuse consent on grounds of the purpose for which the proposed assignee intends to use premises, even though the purpose is not forbidden in the lease. So as you can see, what you're required to do is to understand very well what the facts of the case given, and then try to find the case that has similar facts and relevant principles, then apply it to the facts of the case. The next topic that we'll talk about is leases and licenses. Please bear in mind that our next classes will be in more in-depth discussion about each of this topic and more analysis of problem and essay questions. So make sure that you attend all the classes. This class is only a brief overview of the main topics and a brief overview of how you're required to answer problem and essay questions. Leases and licenses and business lease renewals. You can see our notes at this link for this topic. So leases, there are two types of estate, freehold and leasehold. In commercial property, we focus on leasehold. A commercial lease is the right to exclusive possession of a property for a specific period of time. License is different. If there is no lease, then there is license. So a license gives someone a legal right to occupy the premises. There are formalities involved. When you get a problem question, make sure that you discuss the formalities and you establish whether it's a lease or a license before moving to the next next legal issues to assess. So if for leases more than 3 years, they need to be granted by deed in order to be legal. So make sure that you mention this requirement and you assess this formality in your problem question. There has to be expressed intention, it must be in writing, and it must be witnessed. Cases to read on this topic are London College, Assault Petroleum, and Delmate. Make sure that you click on these links after this session when you receive the slides and read these cases. Forfeiture is also a very important topic that most of the times come up on exams. If you have to answer more than one topic on the exam, sometimes you have to only answer one and you may skip this topic. But if you have to answer 2 questions on your exam, you will most likely need to learn forfeiture. That's why it's so important that you understand very well what are the requirements on your exam and prepare the number of topics that you're required to know, not more than that. Forfeiture, you can read our notes on this. Basically what it means is that when landlord ends a fixed term lease and tenant simply loses everything the rights granted in the lease. This also applies to subtenants and mortgagees who were also involved in the lease. There are certain grounds under which a landlord is granted a right to undertake forfeiture proceedings. There are 2 separate forfeiture regimes. For non-payment of rent, landlord will be entitled to start forfeiture. The landlord remedies for unpaid rent, they can also be sue for arrears, and they can sue commercial rent arrears recovery. That's one of the routes, or tribunals, courts and enforcement act 2007, section 7277 is the regulation under this area. For breach of any other covenant, section 146 procedure has to be followed. The landlord will have to give notice. Well, obviously, landlord cannot just say that, the tenant has to move out. The landlord will have to give notice, and there has to be a breach of the lease in order for forfeiture proceedings to be legal. However, if certain types of covenants are broken, they could be remedied. And firstly, the tenant has to be given opportunity to remedy, but depends on the situation. A covenant to ensure are remediable unless the property already burnt down. Covenant not to alter without consent. If the landlord wants to stop the alterations without consent, then this is a negative covenant. Covenant to repair. Landlord can simply ask to repair. And covenant to carry out works within a stated time. These are covenants that can be remedied. Also, repairing obligations often come up in a problem question. It's very often mixed with another topic that's called quiet enjoyment. So make sure that you have a look at that as well. It is, you can see the notes of these topics on our website. What are repairing obligations? Repairing obligations can be the following: to put premises in repair, to keep it in repair, to maintain in repair, to deliver up in repair. It's the covenant, the wording of the covenant is very, very important. And in the problem question, you have to analyze what the wording of the specific covenant given to you actually means, and then discuss, apply the law to the facts, and advise the party. Relevant case law to understand what is a repair is Credit Suisse, Post Office, Quick and Tough. You can just click on these links after the session and you will be able to read the case summaries when you receive the slides. So repair itself, the word repair, the court stated that it just means disrepair connotes deterioration from some previous physical condition, and repair is an ordinary English word, so it has to be given ordinary English word meaning. That, but there are some provisions that can cause ambiguity. For example, when it says repair, do we have to also renew the parts affected, or do we just have to repair? What if repair is not possible? What if something is so broken that the only way to repair it is to renew it? Does the repair covenant actually include that? So those are the kind of problems that you will most likely face in a problem question on this topic. So that's why it's so important that you read these cases that you can see on this slide. Repair and renewal has been distinguished in previous cases like Ravensift. Repair is restoration by renewal or replacement of subsidiary part of a whole. Renewal, as distinguished from repair, is a construction of the entirety. There are some cases, as I mentioned before, when repair is just simply not possible, and there are only certain types of situations when the defendant will be forced to renew, even if renewal was not part of the covenant. And it's very important that you read the cases to understand how the process works. However, in the next class, before the exam comes in January, we will have further classes for commercial property law, and we will discuss in more details how repair obligations work and what is quiet enjoyment, so that you are better prepared for your exam. To sum up, there are four main things that you need to know. You need to analyze your exam requirements, and you have to adjust your study plan according to what you're required to do on your exam. It is not required for you to know absolutely every case and every principle, everything you covered on the course. On the contrary, your study plan has to be adjusted to exactly what the exam requires, has to be focused on certain topics that you understand the most and that you will be required to answer on your exam. This is the only way to get a high grade. If you try to study every case and everything you covered on the course, the likelihood is higher that you will get confused, and your mark may be lower. So you have to do selective studying. That is the way to increase the likelihood of you getting a first class. Then, once you study the relevant topics, it's highly recommended that you practice answering problem and essay questions. Try to have a look at your past exam papers as well as our model essays. Read the questions and then draft answers yourself, then compare it to our answers so that you know where you went wrong, where to improve. And finally, make sure that you follow your professor's requirements. Grading is subjective, and it's very important that you know exactly what your professor wants you to do. The best way to do this is if you draft a few practice essays from past exam papers, send it to your professor and ask for some feedback. Some universities also offer formative courseworks. that is actually your chance to get some feedback. So formative coursework is not mandatory to do, but it's highly recommended that you do it in order to get some feedback from your professor and you understand better what you're required to do on your exam. Also, another way to do this is to get tutoring sessions with us. Myself or my colleague will be able to assist you with whatever difficulties you have with your legal studies. How can we help? Our platform offers simple study materials for students to get high grades. We have top students and graduates who create content. They have been in your shoes, they have gotten high grades, and they create simple study materials for you. You will have simple notes, model answers, tutorial videos, quizzes, flashcards, and study groups you can join. Also, we offer one-to-one tutoring sessions and group tutorials like this that you can attend for free. If the resources are not enough, one-to-one tutoring sessions are a perfect way for you to practice your legal writing skills, as well as get some further help to prepare for your assessments. We have already helped thousands of law students in the UK to get high grades, and you can see our reviews here. 90% of our regular users get a first class. This is because our platform is designed for you to get highest grades in the simplest way possible, commit less time, get high grades. And the key is in regular study. So if you study regularly with us, the likelihood of you getting a first class increases a lot. So it's highly recommended that you get the annual membership that motivates you to study regularly, and also occasional tutoring sessions to practice your legal writing skills. We would love you to be our next student to get high grades. Please join Simple Study via the following link and join our study groups. Thank you very much.